Hello everyone. DHS actually published their appeals brief late last night. As you can see, it was like 10:46 in the night, so we couldn't update yesterday. So their argument is based on three key items that they highlight in the beginning. The first one is, did the district court, which is basically the court that actually gave the judgment, previously, did they do everything right, and was the judgment correct? That's the first thing they want to look at. And the second one is, did the district court, actually the one that gave judgment, abuse its power by not considering the extra evidence? Yeah. So that's the second one point they want to clarify. And the third one is, if the appeals court, which is basically where the lawsuit is currently being discussed, if the appeals court confirms that there is something that has to be done, challenging the DHS authority, then they should send it back to the district court for review, right? So this is the 3 points. So firstly, if you look at the district court's final judgment, appeal, DHS presents that there was no concrete evidence that they could come out, in the overall, facts presented by Save Jobs, that it will impact their members. So if you look at Save Jobs, their members are basically IT workers that were impacted. That's the key part. So there is no concrete evidence that all the H4 EAD holders will be actually impacting them, right? And so that's the first one. And second one, they could not find any additional benefits for H1B holders. They were telling that in their original argument that there were benefits for H1B holders, that they will stay back and all. But there is no additional benefit as such, because they're anyways employed by their current employers and everything. So there is no additional benefit. And again, there is no increased direct competition for Save Jobs members, because the whole argument is H4 holders can be in any job, and not just IT jobs. So it's not a direct comparison, and there is no direct evidence that there is competition established. And there is no statutory protections that that's impacting their jobs, or their labor laws or whatever, right? So there is no evidence for that as well. That's what they tell. And lastly, they say that there is a fundamental flaw in the lawsuit, because they actually lost their jobs for because of the H1B program. That's what replaced their jobs, and not H4 holders. So they should be actually going against H1B holders and not H4 EAD holders. So that's what one of the arguments they present in the case. Now, I mean, there is much more details in there. You could read our article. It's about 49-page document. So I mean, I'm really summarizing it very shortly, but this is the gist of it, right? And the second one is extra evidence. Basically there was a appendix submitted, which is post-dated, essentially after the rule was published, and they argue that post-dated evidence cannot be used. So the rule that is out there is basically additional evidence can be submitted, uh, you know, but it cannot be post-dated. The logic is you cannot really submit proof, for future dated. It's like, it's completely against, right? So, you're filing a case for a future problem, right? By submitting this evidence. So that's the second one. So basically, they say that on the second part, that the court did do their, the right thing by not considering the evidence in giving their final judgment. And the third one is where they believe that appeals court should not consider an issue that is not passed from below court. What it means is, the topic that Save Jobs USA is raising is, DHS authority to give H4EAD. They didn't have the authority, they exceeded the authority, and things like that. But this was not really the case discussed in the district court, first of all. So the argument DHS is putting over, this was not discussed. So basically, you can't really argue on this point. So the DHS exceeding the authority should be first sent back. If the appeals court, or I mean the current court, believes that DHS exceeded authority and something has to be done, so this has to go back to the district court, where this has to be discussed and then only taken up. Yeah, so they can't really jump in an appeals court on something that was not really discussed in the previous court. Yeah. So, and also they say that this proposed rule is to remove H4EADs is currently in progress, and it's with OMB. So having a decision on this will be like pointless if this is going to be implemented. So overall, they suggest that Save Jobs USA lacks standing to challenge the H4EAD rule, because their claims are basically completely speculative, and the facts were not established fully, and there is no direct evidence that there will be a direct impact for the filing parties in Save Jobs USA. because Save Jobs USA are IT workers, and it's not an apples to apples comparison because not all H4 EAD holders will be doing taking IT jobs and things like that. And also they say that DHS seeks the appeals court to uphold the decision essentially from the district court, and basically hold the way it is. So that's the overall argument that they put up. So feel free to read the article on the blog, and as well as the document. So the next one update is coming up in about a week. So thank you, for watching, and subscribe for updates.